Hello everyone. It's looking like as of January 1st of 2024 that concealed carry in the state of California is going to be effectively banned. This is all because of SB 2 is looking to be signed by Gavin Newsom at any moment. I'm recording this video ahead of time so that I have time to discuss with you the lawsuit that myself and Armed Scholar are involved with. This lawsuit is being put forward by the CRPA, Gun Owners of California, Gun Owners of America, and Second Amendment Foundation. This lawsuit also has several other individual plaintiffs that will be discussing some interesting claims that we're making here in this lawsuit against SB 2, which again is going to effectively ban concealed carry everywhere in the state of California, because knowing where you can and can't carry is going to be so impossible to determine that you would not be able to leave your home. And actually, now that I think about it, I would not be able to walk down my street in any direction more than a mile without actually breaking the law, because I couldn't even be on the sidewalks of many of these locations. So if you have a concealed carry permit in the state of California, you're going to want to pay attention. If you know anyone that owns a firearm in the state of California, you're going to want to pay attention. If you live in any state, this is going to be a lawsuit to follow, because it's going to be one of the continuing battles that we have to fight in the wake of Bruin. Now, let's give you a little bit of a background on SB 2 itself and how it passed. Well, SB 2 was originally SB 918, and now when Bruin, the New York State Rifle and Pistol Association versus Bruin decision came out, making every state have to issue concealed carry permits and get rid of good cause, well, Robert Bonta, the Attorney General of California, and Gavin Newsom and every other Democrat lizard person in the state of California was very upset because they could no longer use good cause as a way to ban people from getting a CCW. Shortly after that, every CCW holder's address and personal information was leaked on the DOJ website in an easy to read and search Excel spreadsheet. Totally random that it happened then. Nothing to see here, folks. Then the legislature tried and failed to pass SB 918 after being opposed by the California State Sheriff's Association. Law enforcement as a whole does not want and did not want SB 918 to pass, which was the previous version of SB 2. So the reason it did not pass is because it required a 2/3 vote in order to get passed, because it was going to be going into effect immediately the second that Gavin Newsom signed it. They didn't get those votes. They only missed by maybe 1 or 2. I keep saying 1 or 2 because I can't remember specifically. There was like a last minute vote change that went from 1 to 2 votes needed. Anyways, it barely did not pass that 2/3 vote. Now, and if you ever didn't think that this was a Bruin response bill or that they disrespected the Second Amendment, in a press conference talking about SB 2, Giffords called the Bruin decision radical, and the Brady group said that there would be disastrous effects because of the Bruin decision. Honestly, question, where are those disastrous effects? Where are the massive numbers of people going through the process that takes sometimes a year in some counties to get a CCW? Where are the crimes? Where are the crimes? Where are the bodies? Now, in that same one, Gavin Newsom used air quotes when he said the word rights to carry a firearm in public. He laughed and used air quotes when talking about your right to protect yourself outside of the home. Yet, only maybe a year or 2 ago, he was assaulted by a homeless person in Oakland. You can't make it up. Now, when a member of the press asked if there was any known issue of people with CCW permits committing these crimes that they're talking about, the governor repeatedly dodged the question, obviously because this is not about safety, which SB 2, the reincarnation of SB 918, is being opposed by the Police Officers Research Association of California, PORAC, and the state sheriff's organization that we already discussed. It's also being opposed by. So the police as a whole do not like SB 2. SB 2, in addition to making everything a sensitive space, is also going to implement what we are referring to, which I think Rob from 2A Updates on Twitter might have been the original person to coin this, vampire clause. What the vampire clause is in order to, as a CCW holder, go into a private business that is not otherwise banned. Let's say somehow the parking lot and the sidewalks are not banned sensitive locations because any other type of business, like a medical center, a place that sells liquor, a place that sells lottery tickets, a fitness center, you know, if somehow the parking lot and the sidewalk that you want to go into this business of does not prohibit CCW, That business would then have to put a sign on it saying, you can come in with your firearm. They are forced to make a statement on a very hot political topic in order to allow someone to exercise their right. Now, Heller originally brought up this sort of test of text, history, and tradition, and it also determined that you have the right to have a gun, and that the Second Amendment is an individual right. It was Bruin that further clarified that yes, these lower courts have been incorrectly using the means end testing, and that they need to use text, history, and tradition to determine whether or not there were analogous laws at the time and whether or not they were intended and similar, whether or not there is a history of banning this type of action that is typically protected by the Second Amendment. Obviously, banning carry everywhere in the state of California, in practice, in theory, is not going to pass. It's not going to pass at all. If any reasonable judge looks at this, they will side with us. And in New York and New Jersey, I believe the federal district courts have ruled in favor of the Second Amendment, which is kind of crazy considering it took so long for these court cases to go through the first time to get Bruin, but now these same districts in New York are seemingly following what the Constitution is supposed to guarantee. So I'm expecting this lawsuit to be very successful. Let's talk about the plaintiffs. So in this case, me being the main named plaintiffs, May versus Bonta, I have perfectly good standing because I would otherwise carry my gun pretty much everywhere I go unless it was prohibited. Now, because I would be affected by SB2 in the following ways, I couldn't go to one of my most favorite gun stores that I like to go to because it shares a parking lot with a sensitive location, and because of that, I would not be able to, with my concealed carry firearm, conceal carry that gun into the parking lot or the sidewalk. I wouldn't be able to go there, even if Sportsman's Arms put up a sign allowing me in. Wouldn't be able to use any public transit, wouldn't be able to use the mall parking lot that I routinely park in to go to any one of the number of businesses in Santa Rosa. And actually, like I discussed earlier, I couldn't even really walk more than maybe a half mile in any direction because of certain sensitive locations that would prevent me from walking down the street in my own community. Oh, did I mention that parks, public parks, you couldn't carry a gun? Yeah, it gets kind of crazy. Now, the other plaintiff that I really wanted to talk about, Anthony Miranda, the armed scholar. I'm kind of excited to be teaming up with him on this one. This is cool. I'm expecting Anthony to also be uploading a video basically probably at the same time that I do. If you want to watch his video, highly recommend it. Now, one thing, I'm going to just talk about each plaintiff, like one little thing that I wanted to talk about. There is a whole lot more to read about why. But Mr. Miranda will also be barred from carrying a firearm for self-defense in his church unless the church chooses to post a sign affirmatively allowing firearms, even though it doesn't currently prohibit those with valid CCW permits from carrying. Given recent attacks in churches that targeted people of faith, Mr. Miranda fears for his life. He knows SB2 would disarm him because he intends to comply with the law, but those restrictions will not stop criminals intent on violence from attacking people of faith. So basically, you're going to be put in a choice where you have to carry with or choose to exercise your First Amendment right to freedom of religion, or choose to have the means to protect yourself. You shouldn't have to trade one right for the other. Now, Plaintiff Eric Hans is a person that is employed in Southern California, and because of his job, routinely has to drive around to unfamiliar areas. Now, as someone that also has to drive around often, you can never plan ahead to the point where you would know every single business that you're allowed to go to. You wouldn't be able to get gas at any of those locations because most gas stations sell lottery tickets, and if they sell lottery tickets other than the California lottery, you're basically screwed. You can't go to that gas station, which is kind of insane. You basically cannot travel further than your gas tank will allow you, and then if you wanted to fill up your gas tank, you have to go home, disarm, go to that gas station, fill up your gas tank. That's kind of ridiculous, or you're gonna have to leave your firearm in an unattended vehicle when you go into any of these businesses. It's kind of crazy. Why would the law require you to leave your firearm in your vehicle more often? Especially in cities like San Francisco. I wouldn't leave garbage in my vehicle in San Francisco. But I'm getting a little bit carried away. Gary Brennan is the president of the San Diego County Wildlife Federation, and as part of his duties, he regularly visits and hikes through public lands. He frequently carries a firearm while performing his duties. While SB2 exempts certain areas that allow hunting, Mr. Brennan regularly travels through areas that do not allow hunting. He is harmed by SB2 in both his role as president of the Federation and his own recreational hobbies. Now, he is also a CCW instructor, and SB2's complexity alone affects his ability to provide certainty and clear guidance to his students, given all of the places where public carry of a firearm is jeopardized by SB2's arbitrary and capricious maze of rules. If you have gone to a CCW training recently, chances are your instructor has made you aware of SB2 or SB 918, because even they are basically saying, if this goes through, you're not going to be able to carry legally. It's going to be impossible to determine where you can and where you can't go, and you're likely just going to end up risking going to jail for bare minimum 2 misdemeanors because your CCW permit is invalid the second you enter one of these sensitive spaces. It's insane. Also, there was Oscar Barreto and his wife Isabella Barreto. Now, Oscar is a former career as a retired California bail fugitive recovery agent, and because of that, he's interacted with a lot of unsavory individuals. But now he would be unable to protect himself and his family. It's kind of interesting how they got both him and his wife as plaintiffs on this. I think that's very interesting. Now, Barry Barami has 2 children of age 10 and 9. He's involved with his family. He likes to take his family out to various locations like train stations and public transit because they're very into trains and they visit railroads and public transit stations. So he would be unable to do so because public transit would be banned. Plaintiff Pete Stevenson regularly takes trips to San Francisco. Good luck, buddy. I'm going to be real with you. As someone that goes to San Francisco often, you're basically rolling the dice. And the easiest way to do so for him currently is to travel by BART, which is public transit. He would be unable to do so. I think talking about BART also has public transit. So if you use the long-term shuttle, the long-term parking lot to SFO, there's a little shuttle system that takes you on there. I believe that might be considered public transit. I'm not entirely sure, but at one of the stops along the way, there is a BART station. So I'm not even sure you could have your firearm in that capacity either. So it's just another example of all these little things that can happen that can make what you're doing illegal without you knowing. Now, Mr. Andrew Harms likes to take his kids to various places in Glendale, such as restaurants for a meal, parks and playgrounds so they can play, libraries so they can check out books, and the Civic Center for various events. All of those places will be off limits. Yeah, libraries, parks, anywhere that you would want to go ever. If you want to leave your house, you're not going to bring your gun. That's basically what SB2 does. One of the most interesting of the last 2 that we're going to talk about is Plaintiff Jose Flores. Now, Jose Flores does not currently have a CCW, but he's in the process of getting one. He's suing on behalf of the infringement on his First Amendment rights. He owns a business, and he wants to allow people to conceal carry a firearm if they choose to do so legally. The problem is, he would then have to put signage on his business that would potentially alienate customers because he wants people to be allowed to exercise their Second Amendment right. He's being forced to speak on something so that someone can do something that is, by default, supposed to be protected by the Second Amendment. He also does not, in there it also says, furthermore, Mr. Flores does not want to be part of legitimizing California's unconstitutional anti-Second Amendment scheme by agreeing to put up such signs. SB2's compelled speech requirements violate Mr. Flores' First Amendment rights as well as his Second Amendment rights once he obtains his CCW. Something we might not have discussed is that any place that offers medical treatment of any kind would also be banned outright from allowing you to have a CCW on property. Now, one of the plaintiffs is Dr. Sheldon. While Dr. Sheldon I'm sorry, man, like if I get it wrong, please email me or something. I think it's Hough, shares many of the issues that all the plaintiffs have in common. The doctor, like Plaintiff Flores, has an additional and unique concern: the status of his own dental office. Dr. Howe has always welcomed people carrying arms in his dental office, and he assumes that many of his customers have CCW permits. He wants his business to continue to be open to all peaceable patrons, including those like him with CCW permits, but he does not want to be compelled to put up a sign saying so. Such a sign may alienate other customers and hurt his business, and he should not be compelled to engage in speech to publicly declare a position on a controversial issue in California. This would be a violation of his First Amendment rights under the First Amendment. Furthermore, even if Dr. Ho wanted to put up such a sign, SB2 contains a separate prohibition for carrying arms in medical facilities like his dental office, a prohibition which also stops him from carrying in his own office. SB2 makes Dr. Howe's office off limits for the public carry of arms for him and his patients. Interestingly enough, if his facility is in a same parking lot or shares a parking lot with another medical facility, even if he allowed it, there's also the fact that any facility would also ban it. So it's kind of tough for him in this instance because there is no legal way for him to have a firearm on his property. Now, this is obviously challenging the Second Amendment claims and the First Amendment claims. I'm interested to hear what you guys have to say and what you guys think about this lawsuit, what you think about SB2 in general. Basically, if you live in the state of California, as of January 1st of 2024, it's looking like you will not be able to legally conceal carry a firearm, because in order to do so, you would have to map out your road in such a way that would require teleportation. There would be no way for you to not have to leave your vehicle unattended, or you leave your firearm unattended in a vehicle. And that to me is just wrong. I should not have to leave my firearm in a vehicle everywhere throughout my day, because then there is no point of having a CCW. It's also just a blatant infringement on the Second Amendment in a direct response to the Bruin decision. It's very clear what they think about the Second Amendment right, which I guess using it in air quotes is technically correct, because it is not the Second Amendment right. It is a right that is guaranteed and protected by the Second Amendment. The Second Amendment does not grant the right. The First Amendment does not grant a right. It merely acknowledges the right's existence and protects it and prevents the government from doing something to act against it. Anyways, let me know what you think down below. You guys know the drill. Have fun, be safe, stay dangerous. Peace.